Good evening and welcome to SAI's panel discussion regarding the amendment of the South African Constitution to allow for expropriation without compensation. Tonight's discussion will be held in English, and please remember to post your questions in the comment section wherever you are watching from. We look forward to answering your questions at the end of the show. Alhoewel vanaand se gesprek in Engels gehou gaan word vir ons internasionale kykers onthaalwe, sal ons beslis julle vrae in Afrikaans en Engels antwoord. Dit hang net af hoe julle dit vir ons in die kommentaar afdeling plaas. Our panel for tonight is again Daniel Elof from Herterspies and Advocate Ben Bester, a member at the Pretoria Bar, who also drafted our commentary on the amendment, and Dr. Theo de Jager, President of the World Farmers Organization and Executive Board Chairman of SAI. Now, the ad hoc committee to initiate and introduce legislation for amending Section 25 has requested further submissions on proposals to amend the Constitution. Specifically, they have asked for further comment on the following issues pertaining to the amendment: where land and any improvements thereon are expropriated for the purposes of land reform, the amount of compensation payable may be nil. The second one, that national legislation must provide circumstances where the amount of compensation is nil. Land be a common heritage of all citizens that the state must safeguard for future generations. And lastly, conditions should be fostered to enable state custodianship of certain land in order for citizens to gain access to land on an equitable basis. Now, before I head over to Dr. de Jager to discuss these four issues and the consequences thereof, Ben, can you just explain the difference between the Expropriation Act and the amendment to the Constitution to allow for expropriation without compensation? I think most of our viewers, and we've received multiple questions relating to this. What are the differences between these two, and how do they relate to one another?
Okay, perfect. Thanks, Francois. So I think the starting point for this discussion would be just to understand the structure of the Constitution and let's call it delegated national legislation, which is then adopted pursuant to the Constitution and constitutional rights set out in the Bill of Rights. So Section 2 of the Constitution provides that the Constitution is the supreme law of South Africa. And thereafter, the Constitution proceeds in the Bill of Rights to set out various different fundamental rights. Now, it is not strange in the structure of the Constitution to see that the Constitution grants a specific fundamental right. For example, one that most people will be aware of is your right to fair administrative justice or administrative procedure. So the Constitution guarantees that right broadly, to say everyone has the right to fair administrative procedure. And then the Constitution in those same sections which provides for those rights would usually say something to the effect that national legislation must be adopted in order to give effect to that right. So you have in the Constitution this broad right, and then the Constitution mandates, so to speak, the Parliament to say, okay, Parliament, you must now adopt legislation which will give effect to this right. And this is basically how one must view the constitutional right to property set out in Section 25 of the Constitution, and how that interplays with the expropriation bill. So at the moment, these two bills must be read in conjunction with each other, because it is most likely what would happen is that Section 25 would provide that there would be, if it is accepted, that it would be able to implement expropriation without compensation. That would broadly be the principle set out in the Constitution. And then the Expropriation Act will give the details, so to speak, of how that expropriation will take place and in what specific instances expropriation can take place with no compensation. So one must be sensitive to the fact that the Constitution is not the document which would detail in effect to say in the following 5 or 10 or 15 instances, no compensation can be paid. How it would work is the Constitution provides that null compensation is possible, and then one would have to go to the Expropriation Act to see when specifically is null compensation applicable. So these two must definitely be read in conjunction. Then, interestingly, and Sai has also commented on this, is the legislature, or rather the executive, has gone further, and they've also issued draft policies. For example, the draft land allocation policy, which is then a further document that one must also take into consideration in order to see where this process of expropriation without compensation is headed. So one has the proposed amendment to the Constitution, which is set out in the bill that we are discussing tonight. That would be the overarching umbrella. Under that umbrella or pyramid, you then have the expropriation bill, and that expropriation bill says specifically in what instances null compensation is applicable or would be applicable. And then even further down the pyramid or under the umbrella, the government has also issued certain policies where you can see how land that will be expropriated will most likely be allocated and who the beneficiaries of that allocation would be. So that is the context which we are discussing tonight.
Where this discussion fits in within the context of these different types of legislation and amendments. Dr. De Jager, if I can head to you, why would government proceed with this amendment of the Constitution when there are dire warnings from the local and international experts about the consequences of such an amendment?
Thank you, Francois. Simply because there's an election coming up. The history of Africa is littered with examples where governments use the land issue as a joker in the pack when they are caught with a poor hand shortly before an election. And there's no different in South Africa. You can just look at the history of issues shortly before elections since the late 1990s. Just before the 1999 election, we saw the new legislation on security of tenure, the ESTA Act, being passed, which is really a nightmare for much more than just the farmers in our country. And then the run-up to the amendments of the procedures for redistribution, which used to be the old SLAG and then became LRAD in 2004. And then in 2008, when Toko Rodiza was Minister of Public Works, we saw the first bite at this apple of expropriation without compensation. And the big thing that saved our skins was the fact that they tried also to close the doors of the courts to the victim of expropriation. Then came 2014, and they amended the Restitution Act. Now, you know, restitution is free land. If you think that we have seen a few dragons and monsters out of the Zondo Commission evidence, just watch the space if we would ever have a similar commission of inquiry into restitution. This process was designed to be abused. Then came 2017, the ANC adopted the resolution on expropriation without compensation at its policy conference, and then drove that to the 2019 elections. They were supposed to get something done before 2019, but because of the split in the ANC, because of the struggle between the camps in the ANC, this thing is being kept alive. And you appeal to the poorest people, to the deep rural people, those who have nothing, who can also lose nothing. They are the ones who are impressed with the jargon about taking land and giving it to someone else. And take Zimbabwe for an example. As you know, I'm heavily involved with the farmers in Zimbabwe. It's actually my constituency in the World Farmers Organization. And I had family who lost all their land in the radical land reform since 2000. You know, this was an issue in the discussions at Lanchester House in 1980. And the outcomes, both the British government and the opposition or the government of Zimbabwe of the time made pretty sure that there would be no space for a new government in Zimbabwe to change this constitution to allow for expropriation without compensation. But the issue surfaced already in 1992. It was the hot topic of 1996 when the MDC was also formed. Then in 1998, government threatened, but it did not do it. In 2000, when it really happened, it was not government. It was the war veterans who took the law in their own hands, and they started to violently take over farms. And they left Mugabe with a very simple choice: fight us, confront us, or join. And he decided he would rather get onto this horse's back, see how long he can stay there. They only changed the constitution 2 or 3 years afterwards to allow for that. Now, the big question tonight, I would say, is, are we like a rat in a pipe in the same direction, on the same trajectory of Zimbabwe? I believe with every cell in my body, the answer is no, we are not. You see, we have something which the Zimbabweans never had. And that's an example right on our doorstep on how not to do things. We can see exactly where that road will take you to. Whenever I quarrel with my cousins who lost everything in Zimbabwe, they would say to me, this argument can only be valid if a majority of people in South Africa have soft ears for the voice of reason. And of course they are right. But you know, if a majority of people in South Africa do not have soft ears for the voice of reason, then we never had a future in this country. I think the truth is that the majority of people in South Africa have not yet really made up their minds. There are too many people in South Africa who have moved into the middle classes, who are also struggling at the end of every month to pay their cars, their houses, the school fees. Can lose something if everything goes wrong. And this is one of the driving forces behind expropriation without compensation, because that middle class constituency, their politics also change. They also get scared of this kind of jargon. So why would our government do something like this? Why would they cause this kind of damage? Similar to the EFF. Why would they knowingly cause the kind of damage to economy which they have seen in Zimbabwe and in Venezuela and elsewhere in the world? Never has a good outcome. The answer is really very simple. It's only us, the voters, who think that governments are in this business to do the best for the economy of the country, to pursue the common good. Politicians are in this game to stay in power. They will do anything to stay in power. In South Africa, this government cannot afford to lose power. So they need to pull off this kind of tricks in order to lure enough votes to stay in power. And it is for this reason why, even if you would forget everything I say tonight, try to make a note about this one. Don't trust the disagreement between the ANC and the EFF when it comes to the change of the constitution. They both have too much to lose. They stand to lose what they cannot afford to lose. And it's not about a principle, it's about power. Thank you.
Thanks, Dr. De Jager. Something that features quite prominently in this amendment is the issue of state custodianship. Can you tell us whether that is something that is viable? Has it worked in the past where we have given access through the other programs like Plus and Slag, where we have given farms to developing farmers, but the farm stayed in the ownership of government, and where they only leased the farms from government? If we are looking to give people access to land, is this a workable solution? Is it because, I mean, the EFF has also suggested that all land should be under state custodianship? Dr. De Jager, I think you're just still muted.
Thank you. Yeah, you know, the issue of custodianship really surfaced in the law in the 2012 court case between Agri South Africa and government on the expropriation of mining rights. And all of a sudden we learned about a kind of expropriation which is not really expropriation. The government does not take ownership, but because it's a custodian, it moves ownership from one to another. At the time, I was on the executive committee of Agri SA, and we were taken completely by surprise. We did not see this thing coming. I'm still not sure where the concept really came from in law. But since then, the government departments were abuzz with the idea of what more can be taken in custodianship. And we saw a number of changes to the Water Act and water administration, water management, because it is also a natural resource. It belongs to the whole nation. Hence, you do not own your water. You only have the right to use that water. But as government is the custodian of it, it can allocate and reallocate it. And it was already in 2014 that at a land indaba in Johannesburg, Minister Nkwinti alluded to the idea of government being the custodian of all land. It's also a natural resource, very scarce. And he argued that government need that kind of custodianship to ensure that everybody has a house to stay in. Everybody has access to plant some vegetables and keep some livestock. And of course, all the alarm bells went off for us. We consulted a number of lawyers to ask, where can this thing be going to, and how do we ensure that we maintain property rights as it is meant to be in Article 17 of the Universal Declaration of Human Rights? Now, I'm afraid that when the EFF entered the fray, they really woke up that monster more than anyone else, and they really stirred the pot and say, this is the way it works in next door in Mozambique. You know, in Mozambique, there's no private ownership of agricultural land. You have a duat, you have a long-term lease agreement. You can even get financing today in Mozambique on the basis of that long-term lease agreement. But the reason is because there's really integrity in those duats. It's very, very hard to get access to a piece of land if you do not have that duat. They really protect those. The other argument with which they came was Germany. A large part of Germany, especially the former Eastern Germany, is today under the custodianship of government, and the land is leased out by a state-owned agency, the BVVG, and they get financed on it. So we had this confrontation in 2018, me and Professor Mohammed Karan and Minister Zukwana, when he said, why can the Germans do it this way, but you are so allergic to the idea? Why do you always say that agricultural financing hinges on title deeds? That you only have access to financing because you have your title deeds as security. Why can't we use the German system? And it was actually one of the German farmers who said, because there is in Germany trust between the banks and the landowner. And in South Africa, where would you get that from? So the idea of custodianship is not so strange in the world. It is how to implement it in a country like ours. And those countries who have successful custodianships, like Mozambique, like Germany, or the former eastern part of Germany, all of them have articulated their ambition to move towards title deeds. They see it as just a step towards having private property rights on land. And we are heading into the opposite direction. The direction in which we are going, or where we are aspiring to, is the one in which Zimbabwe went and Venezuela went.
Perhaps if I can just add on there, my main concern, Francois, you mentioned the EFF pushing the idea of state custodianship, and we saw the whole fracas playing out in the media where apparently the EFF and the ANC walked out on their deal to support this 18th constitutional amendment because the EFF pushed for state custodianship of land and the ANC sort of settled on nil compensation. Whatever nil compensation might mean, I think it's just some clever academic semantics, to be honest. Nil compensation means zero, it means nothing. There's no difference between saying no compensation and no compensation, but be that as it may. My biggest concern is that what this does is it positions the ANC to sort of look like the reasonable party. They're saying, look, we held off the radical EFF. We didn't go for state custodianship. We're settling for nil compensation, as if that is the rational, reasonable thing to do. It's sort of a political good cop, bad cop type of approach. Whether or not it's deliberate or just coincidental, it doesn't really matter, because that's the practical implications of it. Some people might now view the ANC as doing this reasonable thing. So that's my main concern regarding the question of custodianship. And the big problem with sort of the trajectory that we're following is, like Dr. De Jager has mentioned previously, we've seen this movie before. It's not something new. It's not as if we're being caught by surprise. And we should view the expropriation of land and property, and I think we need to make that distinction as well. The 18th constitutional amendment of section 25 of the Constitution refers to property, not to land, although the preamble talks about land and the lofty ideals that it wishes to attain. But it says property. And in the end, it boils down to watering down property rights in general. And we shouldn't view EWC in isolation. EWC is happening with the NHI bill, which is expropriation of medical scheme funds. It's happening with prescribed assets. It's happening against the backdrop of, like Dr. De Jager mentioned, the watering down of mineral rights. We're following a similar path that countries like Venezuela followed, where they flirted with this idea of watering down property rights, where they started with mineral rights, nationalized all oil production, and just a hop and a scotch away a few years later, they're sitting in this predicament that they're sitting in now, and that's the biggest concern. People often say that the slippery slope is a logical fallacy. Well, it's only a logical fallacy if it doesn't, in the end, actually result in an actual slippery slope.
Thanks, Daniel. Dr. De Jager, another comment from you, maybe?
Yeah. We must remember in all of Africa, there are only 4 countries where we really have private property rights on farms. It is here in South Africa and in Namibia, and then in certain parts of Botswana and certain parts of Zambia. But in the rest of Africa, the concept is strange. But then, those are the 4 countries who are very competitive on global export markets. Those are the 4 countries where you have food security, some of them stronger than others. Those are the 4 countries where you see investment coming into the value chains, and they all have growing agricultural economies. Property rights is much more than just the right to have a title deed. It anchors collateral, gives access to financing. It is the very foundation of the free market system. And no matter how you try to bend history, the raw fact is that thriving countries have it, and countries who are struggling do not have it.
Thank you, Dr. De Jager. I think before we get to the content of SAI's commentary that we will submit before Friday the 13th, can we just discuss what is the solution? If we say we do oppose the amendment to the Constitution, what is SAI's position on a sustainable solution to giving access to land to those who want to farm, to those who want to create a successful farming enterprise and create wealth from land? What would you say to this statement, Dr. De Jager?
It's not only about giving access to those who want to farm. It's about rectifying wrongs of the past. It's about land reform. It's about creating a class of profitable black farmers. We need to do that. It's in everybody's best interest to do that. And it's been done elsewhere in the world. Germany, Taiwan, all very successful in doing that. It's about this notion that land reform is being hampered by the willing seller principle, which of course is simply not true. The willing seller principle has not really been put to the test. For some reason, government believes that they are always paying too much for land. Our proposal over the last 20 years was, why don't you involve the banks? If a bank is prepared to finance land at a certain value, surely your risk when you pay that value of paying too much is very, very limited. Because by their very nature, banks are very conservative in their valuations, in their estimations of value. So they would not go that route. They prefer to say willing seller principle failed. What really failed us has nothing to do with the seller. It has everything to do with a corrupt and an inept buyer. It was the buyer who failed us. It is not previous landowners on restitution and redistribution farms. It's not their fault that Minister Nkwinti had to admit in 2017 that more than 90% of all the land reform programs in South Africa have failed. They did not buy failed farms. If they did, why did they do that? Surely, if it is your job to buy farms for land reform, you will make sure that you do not buy your beneficiaries into failure. And this is what happened. Beneficiaries were simply set up for failure. You ask, what's the alternative? You know, the alternative is really not rocket science. It's not new. And it is not even the business community's idea. It is contained within Chapter 6 of the National Development Plan, which was unanimously adopted at the ANC's 2012 conference in Mangaung. And Professor Karan was one of the architects of that plan, which is based on partnerships. And if I can try to boil it out, off into its simplest terms, Chapter 6 says, you buy land reform farms on a 50-50 basis. There is a 50% partnership with a well-established farmer. You put a beneficiary in a partnership on that farm with a farmer who's already mainstreamed in the value chains, and within one generation, you bring that beneficiary also into a situation of profitability, which is what ultimately we want. Not the department. The Department of Rural Development and Land Reform, before they merged again, was very clear at the land reform in Durban in Johannesburg that the priority is to move land from white hands to black hands. And then after they will decide about the jockey. After that, they will see how to equip a new generation of farmers. There's no way it could ever have been successful. Those two are two sides of the same coin, go hand in hand. You must develop a farmer to put in on the land. I think the fundamentals which are being misunderstood in this department is that a farm is so much more than a piece of land. This is the mistake they are making. They turn farms back into merely a piece of land. A farm is a piece of land plus a business plan, plus massive investment, plus the effort of competing on global markets, because there's very few sectors of the economy which is more competitive, where the world became smaller than in the agricultural sector. And every farmer is every day in competition with the best other farmers in the world. You cannot hold a newcomer into this industry and just expect them to make a success out of nothing. There must be selection criteria. There must be an opportunity to be empowered and to learn what this is all about. Usually, it takes about 2 generations for a farm to become profitable. And that's why this plan made so much sense. Get them profitable in the very first generation of the transfer of the land by letting them partner up with a well-established farmer. And so many, literally hundreds of farmers, nearly all the mega farmers in South Africa raised their hands and said, yes, we will do it. And of the 106 implementations of this plan, which we have seen since 2014, only 3 has so far gone through the floor. And there's a very good reason why all 3 of those went through the floor. But for the rest, it's a kind of a guaranteed success.
Thank you, Dr. De Jager. Ben, getting back to the amendment of the Constitution to allow for expropriation at nil compensation, what is SAI's contribution? What does our commentary entail?
Thanks, Francis. So very shortly and simply, as you are aware, this decade is the United Nations decade for family farmers. So the decision was made in order to avoid duplication of commentary and other organizations doing great work and also make their own submissions. In order to avoid duplication from a domestic perspective, the decision was made to provide commentary on the international perspective. And when I say international perspective, I mean there is also a set of principles which regulate international law. So international law is shortly basically the law which regulates the rules between states. And that is a body of law which also regulates expropriation and what type of compensation must be paid under international law when expropriation takes place. So SAI's commentary looks at South Africa's obligations in terms of international law and to see whether or not the proposed 18th Constitutional Amendment Bill aligns with the international legal position, and in short, it does not. Now, why would it be relevant? Well, one might ask, well, international law regulates the relationships between states. It has nothing to do with the domestic law of South Africa, but that is once again not true. If one looks at the Constitution, various sections in the Constitution makes provision for the fact that South African courts, for example, when they interpret domestic law, must take into consideration South Africa's international legal obligations. So there's this body of law in terms of international law which also regulates expropriation. And SAI's commentary basically tests the not the expropriation bill, the 18th Constitutional Amendment Bill, against these sets of international law. And Dr. De Jager also made reference to a portion of it when he made reference to the Universal Declaration of Human Rights. There's a whole body of regional international instruments which also provides for the regulation of expropriation, and that is basically the focus of SAI's comments as far as the expropriation, the 18th Constitutional Amendment Bill is concerned. Now, as you mentioned previously, there's basically been two rounds of invitations to comment upon the proposed amendment. The first one was in 2019, and the other one was this year. And unfortunately, when one has regard to the two different sets, let's call them quickly the 2019 version and the 2021 version of the proposed bill, in substance, the two proposed bills seem identical, which in addition to the international question which we just discussed, also brings into question whether government has in fact considered any of the comments that have been submitted in the first round of comments. It's disconcerting if one has regard to the sheer number of submissions that have been made on this proposal to amend the Constitution, and when one sees 2 years down the line, in essence, the same document being set out and being republished, so to speak, it begs the question whether or not this is a superficial process, or whether government is in fact taking into consideration the submissions made by relevant stakeholders, which include ordinary South African citizens.
Thanks, Ben. So if we're saying that they are going through the motions, and where are we now in the process, and what is the process that, or the steps that lie ahead? And is there any way, is this something that is just going to end up in court? And if we are talking about international law and Section 17 of the Universal Declaration, how does this get to an international court? When in this process does it get there? Daniel, if you can maybe answer this one for us.
Thank you, Francois. Well, perhaps let's start domestically. I think the most important part of this process is it's obviously going to serve before Parliament. We're not sure whether or not it's sort of fait accompli, whether or not it's already, basically done. Like Ben mentioned, we've been seeing sort of a rehashed version of the same bill for a number of years. I think the important thing to mention is, even if the worst case scenario happens and the amendment goes through, that is not the end of the fight. It simply won't just stop there. Amendments can be amended. I mean, that's the entire nature of it. And secondly, it doesn't mean that the fight is over in our courts. I suspect that if EWC goes ahead, we will see, many different cases on individual level challenging government's decision to not compensate for property that they expropriated. And I think every one of those cases will be for tooth and nail. So people shouldn't be despondent and think this is the end of the road. Like Dr. De Jager mentioned, these sort of things tend to, happen in almost the entire world, and it's not cast in stone. So I don't think we'll see an amendment, the final vote on the amendment this year. And who knows what happens? You know, the political climate changes more frequently than the ANC's ministerial cabinet changes. So the more time passes, the more the entire debate changes. We're already not talking about the same conversation today as we were literally just a year ago. Things do change quite quickly. We have an election coming up, and that will definitely play a big influence. Regarding the international question, I'll just touch on it and be happy to pass over to anyone who's most likely more knowledgeable on this particular front than I am. But I think it's important to keep in mind that court cases domestically and discussions like this and submissions and participating in this legislative process is but one forum, one place where you're able to fight this battle of ideas as it's referred to. A court case is another forum, and the international forum is another place where pressure can be exerted. And we need an effort on all these fronts to I believe, stop EWC, to protect property rights, and to try to create a prosperous South Africa where all South Africans benefit from the prosperity, where all South Africans benefit from the protection that property rights offer. So the international stage, I think, is a crucial part of this entire campaign, but it's not the only forum, just like our courts aren't the be-all and end-all where this conversation and this debate should be had.
Thanks, Daniel. Onthou asseblief om julle vrae vir ons te stuur op LinkedIn, YouTube, Facebook of op die WhatsApp lyn. Ons gaan nou begin om die vrae te antwoord. Dr. De Jager, I think probably more than any other farmer in South Africa, you get in touch with farmers from across the world. And what are their feelings regarding this amendment to the Constitution and the road that we are heading down?
You know, Francois, whenever I listen to one of the webinars you present, there's always these explanations by both Daniel and Ben on how all our legislation fits into the overarching constitutional framework. Everything needs to happen within that ambit. Now, when you go beyond our borders, when you go into the international arena, that overarching framework is actually the Universal Declaration on Human Rights. And in that declaration, there's a clause about property rights. And it's very clear, very condensed, and it says no one should lose their property through arbitrary action from the state. And this is the only rule which is applied internationally. Now, especially in the investor countries, especially in our most important trade partners, the global north, Europe, the USA, Canada, they have really very little comprehension of what is driving this. To them, the rule is clear. They cannot understand why property should be taken without being paid for. And of course, they look at other examples. They especially look at Zimbabwe because it is our next door neighbor. And don't underestimate the role of Zimbabweans who are living all over Europe and the US and Canada, and who are also very vocal about what happened there. And apart from these foreign governments and foreign farmers' unions, one of the most important actors in this debate are the multinational structures, such as the World Bank, the IMF, United Nations and its various agencies, especially the FAO, was also very vocal about property rights. And I have experienced it last year, the last week of January in Davos with the World Economic Forum, where I landed up in a meeting right between the late Minister Perenshiri, Minister of Agriculture of Zimbabwe, and the then newly appointed head of the agricultural division of the World Bank. And Minister Shiri wrote me a quick note, and he asked me, please, organize us a dinner with this guy. I need to see him. I got along with Minister Shiri very well, so I asked Martin van Nieuwkoop from the World Bank whether he would join us for dinner, and his response was no. I have nothing to say to the Zimbabweans. Then I said, let's have just an informal chat. If not dinner, can we take you for a beer? Can we take you for a cup of coffee? We just want to hear directly from you what should be done next. And he said, you know what? We can have that chat outside in the corridor over a cup of coffee. Not need to go very far for that. And when we went out, he said to Minister Shiri, I represent a bank, not a welfare organization. And in the bank, we apply certain criteria. We look at your track record. We look at your ability to repay. We see how trustworthy you are. Then we look at the environment in which you need to make the kind of money which you need to repay a loan. And you have nothing of that. And you're not going to have that soon. So the answer in the World Bank is no. You will not have this kind of loan to save you. You should have thought of this before the land grabs of 2000. And then he turned to me and he said to me, do you and your countrymen in South Africa understand that part? And you know, even after the global compensation agreement has been signed last year at the end of July for the Zimbabwean farmers, and it is not a good deal. The Zimbabwean farmers get a fraction of what they lost. Even after that was signed, by which the government did everything you can expect from a government to show his intent to repay. Up to today, they could not find a sponsor, they could not find anybody who would lend them that money. And the Global Compensation Fund is at the moment in dire straits. It's been extended to next year, March. But if the first 12 institutions they approached could not forward them that kind of loan, you think the rest would? I'm not so sure that they will get access to that. The message from the World Bank was, don't go that route, because you cannot turn around. It's like driving an interlink into a 2-track dirt road on a farm and later hope that there might be a place somewhere to change it. And while we are on this topic, Francois, you know, we are not the first and only country who are grappling with land reform issues. You know, there were 64 countries over the last 50 years who embarked on a land reform program. 11 of them had a restitution program too. And also 11 claimed to have been successful. And they have 4 things in common, these 11, which is not the topic of tonight's discussion. But when they embarked on a radical land reform, when they expropriated without compensation, the story always ends the same. At the end, they compensate. Right at the end, even if it takes you 20, 25 years, at the end, even a country like Zimbabwe, the same ZANU-PF who grabbed the land, came up with an offer and say, if we don't compensate, we're in a cul-de-sac. And we will never revive the economy of this country until we have done it. No reason to believe that it will be different in South Africa.
Well, on that note, Dr. Jago, thank you so much. I think we have a couple of minutes left for a few questions. I'm going to put the first one up here on the screen. Dit is 'n Afrikaanse vraag wat vra, in Zimbabwe het die howe ook nie gehelp nie. Wat maak Suid-Afrikaanse howe anders? Is wapens opneem as die howe val 'n opsie? Ek gaan dalk sommer begin deur antwoord te gee aan enigeen van julle 3 oorgee om by my aan te sluit. Ek dink dit sluit eintlik mooi aan by die punt wat ek so vroeër gemaak het in my vorige spreekbeurt, dat ons howe is maar net nog 'n forum waar ons hierdie stryd moet voer. Dit is nie die enigste plek waar dit gevoer moet word nie. Die tweede ding is, wat ek altyd sê bemoedigend is in Suid-Afrika, is ten minste gaan die ANC nog deur die moeite om die grondwet te wysig. As ons in 'n situasie gesit het waar hulle net eenvoudig in elk geval grond gevat het want hulle het die monopolie op geweld, was dit 'n aansienlike ander storie en 'n ander prentjie. Die feit dat die ANC wel nog afslaan op ons grondwet, wel nog afslaan op die regsproses, dink ek sê baie van ons howe ten minste nog op hierdie punt. So dit is ek sou sê daar's nog wel 'n rol wat ons howe te speel het. En ons howe het 'n redelike mag wat hulle binne Suid-Afrika uitoefen en ek dink dit sal nie net so eenvoudig gebeur nie. En dan soos wat ek vroeër genoem het, dis nog 'n plek om hierdie stryd verder in te voer.
As ek by jou kan aanvul, Daniel, ek wil dan ook sommer verwys na 'n vraag wat bietjie vroeër vanaand deurgekom het van advokaat Johan Hamman. Gevra het, can you tell us how the war veterans practically took the land before the Zim constitution was amended? Onthou, dit was 'n wysiging aan die grondwet in Zimbabwe wat eintlik nie sneller getrek het, maar dit was 'n mislukte wysiging. Want alhoewel ZANU-PF 'n oorweldigende meerderheid in die Zimbabwese parlement gehad het hulle toe hulle referendum hou die 12de en die 13de Februarie 2000 daardie referendum verloor 55-45. So die wysigings in Zimbabwe in die parlement was afgestem. In die referendum was afgestem. En dus net na daai uitslag van die referendum wat die sogenaamde war veterans eenvoudig plase begin beset het. As jy nou vir my vra, in my persoonlike hoedanigheid as 'n boer in Suid-Afrika, of ek bekommerd is oor die eienaarskap van my plaas in Limpopo. Of jy sê, ja, natuurlik is ek. Jy moet jou kop laat lees as jy nie bekommerd is in die huidige tydsgewrig nie. Maar meer as wat ek bekommerd is oor onteiening met 0 vergoeding, is ek bekommerd oor grondgrype. Soos wat dit in Zimbabwe gebeur het. Laat hierdie ding eenvoudig hande uitdruk en dan het niemand meer handvatsels op hom nie. Die soort van ding wat ons gesien het in die laaste maand of so in Natal. Want dis waar die angel van dit sit. Wanneer 'n regering moet kies vir of teen plunderaars en hy nie kan bekostig om 'n groot deel van sy steunbasis te verloor nie. Nou, as dit dan nou kom by die rol van die howe op die oomblik hierin, ek dink veral ons grondwetlike hof, en daar het 'n hele paar uitsprake gekom wat jou as gevolg van jou eie agtergrond en waar jy in die Suid-Afrikaanse samelewing inpas, so half dwars in die keel laat vassteek, maar daar het ook 'n paar baie dapper uitsprake gekom wat vir mense sê, maar hier is 'n raamwerk waar daar nog integriteit in is, wat nie net sommer so maklik gaan buig en gaan breek nie. In Zimbabwe het dit nie meer gehad nie. Ek dink die heel beste gevalle studie was toe generaal Majuru sy plaas gevat het. En dit hof toe gevat is en die hof gesê het, dit was onreëlmatig. Dit moet teruggegee word. En dit is nooit nie, tot met sy dood, kyk hy doodgebrand in daai plaashuis, tot en met sy dood in 2011, het hy eenvoudig homself afgevee aan die reg en daar het niks van gekom nie. Terug te kom na Johan Hamman se vraag toe. Daai grondwet is op die ou end eers in September 2005 gewysig, terugwerkend om voorsiening te maak vir die grondgryp van 2000 af. So ek stem heeltemal saam met Daniel dat ten minstens hier by ons is daar nog 'n tipe van 'n integriteit in 'n proses, sogenaamde deelproses. En ons moet daaraan vasklou aan dit en aan 'n vrye pers, want dit is die wigte wat die teenwig moet in balans bring.
Baie dankie Dr. Jager en ek gaan dan so afsluit aangesien ons die al amper op 'n uur staan. Baie dankie menere vir julle bydraes vanaand, Dr. Jager, Daniel, Ben, Soos altyd, ons waardeer dit baie. Saai sal dan namens familieboere voor Vrydag die 13de ons kommentaar indien op die wysiging van die grondwet. Indien jy hierdie kommentaar van ons wil steun, klik asseblief op die skakel op ons Facebookblad in die kommentaar afdeling is daar, of jy kan ons webtuiste besoek by www.saai.org. Like dan ook asseblief ons blad en enige van die ander sosiale media forums, ons is op YouTube, LinkedIn en Twitter. Jy kan ook vir Dr. De Jager en vir Daniel op Twitter volg. Hulle deel gereeld hulle wysheid met ons daar. Meneere, baie dankie. Lekker aand. Ons praat weer.